Ouslander.
Good morning, Your Honors. I, too, at the outset, would like to reserve some time for rebuttal at the end of arguments. May it please the Court, I am the pro se appellant Charles Ouslander, and this case, Your Honors, is about the legally enforceable rights that public employees have to all of their retirement benefits, including their cost of living adjustments. These contractual, non-forfeitable rights, these promises, were codified in a 1997 law that's been discussed this morning. The law was clear, it was specific, and it intended to protect all pension benefits for public employees. The appellate division down below, in a 3-judge panel, wrote a 60-page plus opinion, and they conducted an exhaustive and comprehensive review of the statute, the Pension Adjustment Act, the history of pensions and their funding, and came to the proper conclusion, as other appellate division cases had prior to it, that cost of living adjustments are part and parcel of a pension benefit. The case that is the subject of the appeal today is the third case to determine that COLAs, that is cost of living adjustments, are part and parcel of the pension benefits. The state neglects to mention those cases, or if it does, simply ignores their effect. COLAs stand on an equal legal footing based on the 1997 law with base pension benefits. The rules governing statutory interpretation are clear, and the appellate division properly used them in interpreting the 1997 non-forfeitable contractual rights statute. Now, the critical phrase is benefits program. It's been discussed here. I would like to break it down and deconstruct the state's erroneous argument about why a broad, encompassing term somehow excludes COLAs. The plain language of the statute says that the benefits program shall not be reduced. It didn't say pension benefits shouldn't be reduced or benefit, singular, shouldn't be reduced. It said the benefits, plural, program shall not be reduced. Although the statute defines what the non-forfeitable right is, it did not have a sub-definitional section defining what the individual words benefits or program meant. Tellingly, the state at one point uses a dictionary to define the word reduce, as in the benefits program shall not be reduced. They did not use that same dictionary to define the terms benefits or program. We know that benefits are plural. We know that a program is a statutory scheme or plan. It's a very broad, encompassing phrase that includes all the pension statutes, including the Pension Benefit Act. The internal inconsistency in the state's argument is they've misconstrued the clear indication test of the Federal Contract Clause analysis. It's correct. In order for a statute to be interpreted as providing private contractual rights, it must clearly indicate that it's a contract and the terms of that contract. What the state has failed to inform this court is that in the leading contract clause analysis case, aptly entitled United States Trust versus New Jersey, the United States Supreme Court indicated that rules of law, statutory construction, and other state law pertaining to the interpretation and enforcement of contracts are part of the analysis. Specifically, in one of the footnotes to the case, it reads, the obligations of a contract long have been regarded as including not only the express terms, but also the contemporaneous state law pertaining to interpretation and enforcement. This court has said the law which subsists at the time and place of the making of a contract and where it is to be performed enter into and form a part of it as if they were expressly referred to or incorporated in its terms. Now, I know that Justice Patterson had asked Ms. Riley whether the rules of statutory construction in our state, that is, pension statutes are to be liberally and favorably construed to the pensioner, apply. Yes, they do. They are officially incorporated into the clear indication analysis of the contract clause. They're not separate and apart. One doesn't take precedence over the other. It's expressly incorporated according to our United States Supreme Court. Well, that rule of liberality says then we should interpret the phrase benefits program favorably towards pensioners. Now, there's also been discussion about what was excluded.
Before you get there,
Yes, sure.
This court in Spina has said that the language must be so plainly expressed that each individual legislature would not doubt that they understood and intended the language as a contract. Do you accept that language?
I do, and I think it's a rephrasing of it, but it stands for the same thing, that they clearly understood what they were doing when they enacted the statute and provided contractual rights.
And we should assume the legislature understood that standard in 1997 as well.
I wouldn't say it's an assumption. I think they did understand it, and the reason they did...
So look to the language and tell us the reason that they did.
Yes, Chief Justice. When I look to the language, you have to interpret the statute. Again, there are rules of statutory construction that this court has given us, that we read the plain language. We may also look at extrinsic evidence such as legislative history, but there are also rules about how we read the statute in combination with other statutes. Now, in this case, they indicated that the benefits program shall not be reduced. As I was indicating a little earlier, we don't have a definitional section regarding those words. And I think Justice Albin was asking Ms. Riley, well, what's a benefit or benefits? Well, we know anything that the state gives as part of its retirement program is a benefit, whether it's health care, a base pension benefit, a cost of living adjustment. They excluded only one thing in the universe of benefits, health care. And as I indicated in my written submission to the court, the reason they did that is they didn't want confusion whether health care benefits were included. Why? Because the State Health Benefits Program, that's the actual title of our Health Insurance Act, might be confused if you just use the broad encompassing word benefits program. The very fact they saw fit to exclude health care benefits, which is their right, shows you that the phrase benefits program was extremely broad. It might be confused as including health care. Well, what other benefits are there in the benefits program for a retirement system or fund? There's only two others. There's a retirement benefit, which is the base pension benefit as we've been calling it, and a cost of living adjustment. Ms. Riley's interpretation of the clear indication doctrine fails because if it's applied based on what the state's conceded in its brief, that only base pension benefits are included, what they're saying is the rule is as follows. Unless you precisely use the exact terms in the statute, it's not a contract.
But
what
Mr.
other...
Ouslander,
Yes.
if I may, when we talk about the benefits program, and clearly the end result is a retirement allowance,
Yes.
but the benefit program also contains many other features, such as the service requirement, the age at which one can access it, and then it also addresses for those people who go beyond the basic qualifying time of age and service, and provides what benefit they will receive if they serve another 5, 10, 15 years. That's all part of the benefits program, correct?
Correct.
So it's and all of that, when you factor it in, yields the retirement allowance. The basic retirement allowance.
That's the formula, correct.
That's the formula. So, but when they're talking about the benefits program, it's all of the rules that apply to be so that you can obtain that benefit, that retirement allowance.
It includes those and all the other laws under the retirement systems, including the Pension Benefit Act, Your Honor.
And is it your position that the non-forfeitable right applies to that formula? That, in other words, the legislature could, for those who have vested, they cannot modify those rules.
Correct. Correct, Your Honor. And the reason benefits program is so broad,
it's something more than the basic retirement allowance.
Absolutely. It's that, it's the COLA, it's all of them. What I was initially saying is
in there the COLA.
Well, I say the COLA and the basic pension benefit analysis is what happens is as follows. You receive a basic pension. You get a COLA based on the formula. It's a 60% difference in the CPI after your initial 2 years. They need a base year for inflation, then the next year they subtract it, multiply by 0.6. That amount is added to your pension. It may come out administratively as a separate amount, but your next COLA is based on the full amount. It's not based on the base amount that you originally got. So that's why I'm saying to you, as they did in Hayden versus Hayden and Old Bridge versus Old Bridge Township, a cost of living adjustment becomes part and parcel of your base pension benefit. And that's why, frankly, COLAs do increase the cost of having a defined benefit plan because they're added to it, and that's when you then compute the next COLA adjustment.
Go back to the argument you were beginning to make earlier.
Yes.
I think you started to say the state's argument that the language must be expressly included in the statute
Right.
fails because?
It fails because they don't apply it to themselves, only to the plaintiffs. One of the issues, Your Honor, is that the pension statutes are fairly detailed and voluminous. There are different benefits within the benefits program. There are service retirements, there are special retirements, there are deferred retirements, there are early retirements, there are accidental disability retirements, there are ordinary disability retirements, and there's cost of living adjustments. Not one of those multitude of base retirement benefits is mentioned in the statute. So if you take the state's argument to its logical conclusion, what they're arguing is essentially what they argued in Burgos last term before this court, that the statute is void for vagueness. It's so ambiguous, it's so unclear it can't possibly be enforced.
But that's the opposite. They're arguing for plain language, that there's a plain language interpretation as you are, but they are then stating that if there is an ambiguity, essentially the tie goes to the state because of the nature of the very high standard that's applied in a contract case. This is not a normal...
That's their argument, and the reason that fails, Justice Patterson, is the excerpt I gave you from the leading Supreme Court case on contract clause claims. That when you're looking at the formation of a contract and its individual terms, you look to state law, its rules of interpretation, its statutory rules of construction.
But do you have anything to cite that would tell us that in a case where there is an ambiguity in this statute, that your contract argument can prevail? Now, you have a plain language argument, but then you go on to tell us if it's ambiguous, go to legislative history and you to talk about legislative hearings and statement by a legislator and so forth. Why isn't it a simple proposition that under this very high standard that governs contract cases as opposed to virtually every other type of statutory interpretation that this court or any other court could undertake, that if there's an ambiguity, it's game over?
Well, I don't believe that's the state of the law. I think what the state has done is to take the standard and enlarge it. Even in Burgos, this court talked about a clear indication that there was a contract.
Well, just to go, the Chief mentioned to you Spina,
Yes.
Plainly expressed. Let's use
Right.
plainly expressed, okay? So if we accept, and I think you accepted when the Chief asked you, that the standard is that the contract right must be plainly expressed. How can something be ambiguous and also be plainly expressed?
Well, I think the difference is, and maybe this is just the common sense reading, understanding, and interpretation of the words of the statute, that benefits program to me includes essentially every benefit except the one that's excluded.
Let me
you don't perceive an ambiguity.
I'm sorry, my question obviously wasn't clear. I'm not referring to the language of the statute. I'm talking about the standard that applies.
Right.
Can a statute, any statute, in a contract case, be both ambiguous and plainly expressed? To me, those two seem to be...
No, I would agree. If you're saying can those two coexist, no, I don't perceive that ambiguity.
Right. So when you go on to tell us, after your very well-written plain language argument, that if there's an ambiguity, you still win, how can you make that argument?
Well, again, because the contract clause analysis incorporates state laws and state rules of statutory construction, we'd look at legislative history. There's nothing wrong with looking at legislative history.
We don't get to legislative history unless we have an ambiguity under those state and
Under
federal
rules of statutory construction.
Okay, so if we go to legislative history, if we've crossed that line, we are now in ambiguity world.
Well,
Am I
I'm
correct
arguing the
about that?
alternative. I don't believe there is an ambiguity on the plain language for the reasons I was just expressing.
Understood. But let me just
Assuming
ask
there
you a
were-
plain question. If we reach the point where there is an where we determine there is an ambiguity of this statute, how can you win?
Well, for the reason I said is that you're looking at the language and the circumstances, whether they evince a contractual obligation. United States Trust versus New Jersey didn't just say, look at the plain language, game over. They went a lot further. That's the footnotes I was quoting to your honors. It is more extensive. It's not just a rule that says if it's not in the plain language. Because if that's true, Justice Patterson, then their argument is it doesn't mention any of these different benefits. The first sentence in the state's supplemental brief to this court was, no one contests that the base pension benefits are covered. Those words don't appear in the statute. How could they possibly have divined that?
Maybe the state is conceding more than it needs to concede, but our issue here is with respect to COLAs. We have one narrow issue here. With respect to COLAs, does the statute with sufficient clarity express a contract right, or does it not? And my question again is, if there's an ambiguity on that point, how can you argue that you win on the contract language?
I win, Your Honor, because there is no ambiguity.
Okay, I completely understand.
The base benefits program has to be divined, and we have rules that help us divine it.
And you have very ably set that forth. But when we reach ambiguity, haven't we reached that result? If that's
well, to the extent that there is an ambiguity, then the fallback is you look at extrinsic evidence, because extrinsic evidence is used only to resolve an ambiguity, not to introduce one. And because the U.S. Supreme Court has said we use all of the rules that a state has regarding statutory law, interpretation, and enforcement, the next step, and this would be my segue into it, is the legislative history. Even if the state misperceives an ambiguity, or this court is concerned that the phrase benefits program, which is broad and covers everything, and the only exception in the universe of benefits excluded is health care benefits, then you look at the legislative history. And what happens there...
I don't mean to interrupt, because you're talking about the plain language. Why haven't you shifted to paragraph B? Is that language not important?
I'm sorry.
I have a non-forfeitable right to receive benefits.
Under the laws governing the retirement system.
Yeah.
Your Honor...
You haven't talked about that language.
I will address it, and then I will get back to Justice Patterson on legislative history. The laws governing the retirement system, in my interpretation of the plain language, is that it covers cost of living adjustments under the Pension Adjustment Act. And it's almost tautological. The Pension Adjustment Act is self-explanatory. What does it do? It adjusts pensions. For what purpose? For the corrosive effects of inflation. It's not a statute that deals with land use or criminal procedure or matrimonial law. What does the Pension Adjustment Act do? It adjusts pensions for retirements. Does it include all retirement benefits, such as private sector benefits? No. What do you have to do to invoke the Pension Adjustment Act? You have to obtain, lawfully, a state-administered pension benefit. If you do, that triggers the effect of the Pension Adjustment Act 2 years once you retire. What is the purpose of the Pension Adjustment Act? It can only be one thing. It is tautological. It's the laws governing the retirement system, and it applies to all the funds that are active. The only exception Ms. Riley mentions is 2 defunct funds that have been closed for about 50 years. Those funds are irrelevant legally and factually to any interpretation of the statute. The 7 state-administered pension plans have many things in common and many things that are dissimilar in terms of the formulas for benefits, length of service, types of retirement. But they have many things in common. Everyone vests at 10 years. It applies to all the pension funds. Everyone gets a Pension Adjustment Act, COLA, after 2 years. So the phrase, under the laws governing the retirement system, includes them all. I know that Ms. Riley finally had to find a reason that she could narrow the meaning of that phrase. And I think it was plaintiff interveners who ably stated in their brief, when this matter was before the appellate division, there was a supplemental brief submitted to Judge Reisner and her panel about the Internal Revenue Code and the tax consequences. And in their brief written submission, the state conceded that the first 5 paragraphs that deal with the Internal Revenue Code, that is the state law bringing us into compliance to make us a qualified pension plan, had nothing to do with the non-forfeitable right. Finally, in their second or third brief to this court, they said, you know what? Section 1 of the 1997 non-forfeitable law, those are the benefits programs that are important. They never made that representation. In fact, in the appellate division, I pointed out that they never even gave an interpretation of the phrase benefits program. In one of their briefs, they said whatever rights the statute grants, and then go on to make a point. They've never defined the phrase because they recognized, finally, belatedly, it was a very broadly encompassing phrase that included everything, the sole exception being health care benefits. So, Justice Alban, I agree that phrase, under the laws governing the retirement system, clearly encompasses all of those laws, because what else does the Pension Adjustment Act do? They've read it out of the Act.
I don't mean to sidetrack you from your legislative interpretation, but just getting back briefly to the standard in SPINA, the standard is what would the legislators have plainly understood by the language they put in the statute, correct?
Yes.
So that seems to require a plain language understanding. Yes?
Yes.
It's one thing to look to legislative history to buttress the plain words. It's another thing to use the legislative history to clear up an ambiguity. And this is the point I think that Justice Patterson is saying. If you've got to clear up an ambiguity, then the language could not have been plainly understood by the legislators. Are you following me?
I do, Justice Alban. I understand the argument. I believe that even under SPINA, I don't think it changed the rule that it be clearly indicated. But I also believe that because of the information I provided regarding United States Trust versus New Jersey, that those rules of statutory construction are incorporated into the analysis.
Yes, but they're not necessary to clear up an ambiguity. Those are means of telling you what the words mean through the canons.
No, and I understand that. And that's
construction.
Favorable construction.
Like general provisions are broadly read, exceptions narrowly. Right. That's understood by lawyers, judges, and hopefully legislators as well, right?
Yes. But that's why, Your Honor, I've spent a great deal of time in my written submissions to the court defining those words, benefits program, and the state doesn't. It simply says it applies to the base pension benefit without more. I mean, you do have, in order to define something, you have to necessarily limit it. The words benefits have a very specific meaning, and they're in the plural. They're not in the singular. And when you talk about a program, you're talking about a statutory scheme or plan. So my interpretation of that dispositive phrase, benefits program, is that it includes all retirement benefits within the entire pension law, the only exception being health care benefits. And while I'm on that point, there's nothing in the Internal Revenue Code that required the non-forfeitable right to be actually enacted, and the fact that they excluded health care benefits has absolutely nothing to do with it. Nothing. That point was made by plaintiff interveners in their briefs and also in the supplemental briefs before Judge Reisner on the tax implications. The reason I mention legislative histories, Your Honor, is that it's absolutely clear, based on Senator Inverso, who proposed this amendment to the bill, that he wanted to provide ERISA-like protections to public employees. And I believe it does inform, as I've indicated, that the rules of statutory construction are part of the analysis. And it's absolutely clear from his statements that he wanted to ensure that people had protection for all of their pension benefits. But if this court is concerned that legislative history isn't sufficient, I still come back to the fact that the state, when it defined benefits program, and it mentioned, in fact, that the program shall not be reduced, it would have to include cost of living adjustments, because they're talking about a program and not benefits. Now, there's a second argument.
Ouslander, does the legislature ever refer to it as a retirement benefit? Because I'm going to draw your attention to the reference in the retirement scheme statutes themselves to the pension adjustment benefits, as I did with your adversary. Look at PERS. They're all the same. They have the same first sentence in all of them. They refer to pension adjustment benefits provided by the Pension Adjustment Act.
Right.
And then later in the same sentence, they demark basic retirement benefits, again, plural, provided by the retirement system. So it seems to me the legislature is accustomed to referring to benefits plural, and yet you're ascribing the plural use in the non-forfeitable rights statute as having some special meaning there that has to include COLAs.
and I'm having trouble making the leap that you're asking us to make, simply because in the non-forfeitable rights statute there is a reference to benefits, but not specifically to COLAs, that the legislature unmistakably meant to include them. Could you help me with that?
That's the phrase program. That's then modified by benefits, Your Honor. It talks about the benefits program. As I've indicated, the program is the statutory scheme or plan for the laws governing the retirement system.
That's in subsection A.
Correct. That's the definitional section, that the benefits program shall not be reduced. I mean, that phrase, again, was
Can that override the reference in subsection B that talks about where they expressly create the non-forfeitable right, and they create it to receive benefits as provided under the laws governing the retirement system or fund?
Correct. And I believe, as I indicated to Justice Albin, that's the laws governing the retirement system includes the Pension Adjustment Act, because we have case law that COLAs are part and parcel of the pension. They just adjusted for the effects of inflation.
I understand your argument, and that's consistent with your brief, but if you could just take it one step further, because when I go back to the actual statutes in the retirement system, hitting the language that I'm drawing your attention to, in each of the statutes where the pension adjustment benefits are referred to as separately being created by a different system.
But I think, Your Honor, the way to look at it analytically is that, and this is what the Appellate Division did when it did its analysis of the history of the Pension Adjustment Act. There was a time when they were pay-as-you-go. They were not pre-funded. And by making them paid ahead of time by both the employer, the state or local government employee, and the employee, they were fully integrating them. And that's exactly what the Appellate Division ruled. I believe that by pre-funding it, that was one of the ways that they made the COLA and the base pension benefit one and the same. The whole idea of the Pension Adjustment Act or Pension Benefit Act is simply to adjust pensions for inflation. It's not adding or taking away. It's trying to maintain the purchasing power of that pension.
The whole purpose of the amendment, changing it from pay-as-you-go, was to ameliorate the consequences on local governments.
I think it's both. I don't think it's an either-or. One was to save money. One's to make sure that the COLA is available. Because if you look at the vestigial statute, if a local employer didn't pay that component to its COLA, a COLA wasn't paid out. I think between both pre-funding...
In history, that never happened, though, did it?
I'm sorry?
In history, that never happened, did it?
I don't believe it has, Your Honor, but the fact that they did it to ensure it being paid in conjunction with the non-forfeitable right shows they intended this to be paid continuously just as a base pension benefit.
Can you show me where in the legislative history for that amendment to from pay-as-you-go to...
It was done in the 90s, Your Honor.
Yeah, I don't recall seeing anything in the legislative history that supported the melding that you're suggesting.
No, of the 1997 law?
The one that changed the pension adjustment statute to make it no longer pay-as-you-go, but a liability. I believe it was done in parts. It started in 1990.
No, it wouldn't have, because that occurred before the non-forfeitable right occurred as a contractual right. But by ensuring that it was being paid, Justice LaVecchia, and then you have in conjunction now in 1997 that the benefits program shall not be reduced, it's integrated it. That's when you have intervening case law from the Appellate Division indicating that a COLA is part and parcel of the pension. I think it's a historical narrative, and that they took notice of that in 1997 when they used that broad, plain language phrase, benefits program shall not be reduced.
I understand.
That at that point in time, you've had this evolution towards the two being one and the same. And again, since we're talking about statutory construction, I think it was Justice Albin who may have mentioned the legislature is presumed to know not only this court's decisions, but its own legislative history. So by the time in 1997, when they drafted this, and Senator Inverso indicated he wanted to protect cost of living adjustments and pensions, that whatever one accrued, whatever one had vested in, they would receive, that at that point it was fully integrated. I don't mean to mislead the court that there was statements in that legislative history prior to it, but that evolution, which is exactly what the Appellate Division down below held when it did its painstaking narrative history of it. I mean, I believe the phrase, it's hard for me to believe that the state is going to concede base pension benefits based on benefits program and then say, well, you didn't mention cost of living adjustments by name, when there are about 7 or 8 other retirement benefits that would have had to be listed by name. There's one rule that applies to everyone. Either they're saying the statute's unconstitutional, as they did in Burgos, or it's not. The problem is in 2006, they provided a formal legal opinion to the state treasurer indicating that, in fact, this was a contract and it provided pension benefits. Now, there's a dispute about whether they didn't say the word COLA, they didn't say the word base pension benefit. But they did talk about ERISA. So other than Senator Inverso, it was the state that raised ERISA and did a comparison between the non-forfeitable right in our state statute and the non-forfeitable right in ERISA. Remember, that phrase, non-forfeitable right, is a term of art, Your Honors. It came from the Employment, Retirement, Income Security Act of 1974. There's a reason they used that word. They were providing the same benefit under state law pursuant to State Senator Inverso's desire to provide the same protections to public employees that private employees had. I don't think you can ignore that. And that's from the state's legal opinion 10 years ago. Then in 2010, the Appellate Division in NGA versus State essentially agreed with a concession by the state. Yes, it provides non-forfeitable contractual rights. Their argument will be, well, we didn't say exactly what was covered. Well, according to their 2006 legal opinion to the state treasurer, they said that the benefits package, that was their word, package, cannot be reduced. I think they fully understood it included everything except health care benefits.
But you would agree that our job is to interpret not some Attorney General opinion, but the language of the statute and whether or not the legislatures clearly understood the amount of sovereignty that was being given up.
I do, but I think that their concessions and their admissions are also relevant in the analysis, Your Honor, well before this dispute arose. I believe that's something, again, as I indicated in U.S. Trust versus New Jersey, you may consider all of the circumstances that evince a legislative intent. I don't think it's simply looking at the statute. Otherwise, it'd have to write a full-length contract, and that's not what the statute was meant to do. The statute was meant to provide contractual rights. It used appropriate, broad enough language.
But you're not contending there have to be a full-length contract. There could be the legislature could have, had it intended to include COLAs, put it in a definitional section, benefit programs, and here's what they are, and they include COLAs and cross-reference the statute. I mean, I think it could have been done, what you are saying they did could have been done with clarity very easily. Am I correct about that?
I think when crafting a statute, Your Honor, they're trying to draft it so it's clear and understood. I don't think they were going to write a statute that listed 8 or 9 different retirement benefits because they'd be rewriting the statutory scheme. I think they used the phrase benefits program, and I emphasize the word program as referring to the entire statutory scheme.
But the legislature constantly uses definitional sections to clearly state rights or the limitation of rights, and it seems, at least in my experience in reading a lot of statutes, to have no issue whatsoever with a definition that includes a number of different items. So wouldn't that could have been done in a paragraph?
They did define the non-forfeitable right as meaning that the benefits program shall not be reduced.
But there's no definition of benefits program, and when you mention that there's a suggestion that they had to write a whole contract, they could have done this with a definitional section, could they not?
I mean, that they could have, of course, but I don't think it was required under the existing law, Your Honor.
But they also knew how to provide for an exclusion because they did it.
Correct, and I pointed out that phrase benefits program is so encompassing that it would have included the state health benefits program, which by name, that's the actual name of the statute. And I think that maybe the court should, when it looks at both of these words, benefits program, one is in the plural, one deals with all the different retirement benefits, and the other talks about a statutory scheme or plan. That's program. This court has referred, as I've indicated in my submission, to plenty of programs. Even in Spina, they talked about the pension program.
But you can't just look at, you have to look at the next sentence, too.
I understand under the laws governing the retirement
benefits program, and then there was one benefit that the legislature decided to exclude, medical benefits.
Right.
What's your understanding as to why the legislature did that?
I think that was just simply the intent of the legislature to exclude medical benefits. It had nothing to do with the Internal Revenue Code.
But it's also, that's a negotiable term, correct? They wanted to make it quite clear that that still was within a term and condition of employment that was negotiable.
I don't know if that's necessarily the case, Your Honor. I do know that by excluding it, they intended not to provide it non-forfeitable contractual rights.
But the legislature may have thought we just can't afford to guarantee medical benefits going forward. That's the breaking point.
That's possible. And the reason they specifically excluded it is they might have thought the statute as written was sufficient. Maybe, Your Honor, they thought health benefits are negotiable. But the problem is benefits program is such a broad term. And as I've indicated, the state health benefits program, that's the name of the health insurance for actives and retirees, might have been included. So my point by bringing
also
that up,
very expensive, as we know.
yes, it's expensive. They may have wanted to limit costs.
So one could understand the legislature, wanting to draw limits.
Yes, but by drawing limits, again, to define something is to limit it. By excluding health care, you've also included everything else under that broad phrase benefits program. If you start from the premise that benefits program includes all retirement benefits of any sort, and you only exclude one, then you're left with the remainder. I believe that's clear from this statute.
What's the class that's affected?
Mm-hmm. Well, in terms of the non-forfeitable right, the class would be between 1997 and 2011 who retired before the law took effect. Now, the law was repealed prospectively in 2010. So as of May 22nd, 2015, the last person received their 5-year non-forfeitable rights. They attached.
So you're saying just the people who retired between 1997 and 2011?
No, that's one class. Then you'd have those people who retired after 2011, but the non-forfeitable right attached. It would be all retirees, Your Honor.
Okay. From your perspective, the
Yes.
class of people whose COLAs are protected, who are they?
They would be those between 1997 and 2011, and there would be two independent legal bases. One, the non-forfeitable contractual right. Two, equitable principles that I wish to address. Those prior to 1997 who did not have a non-forfeitable contractual right because they weren't employed on or after that date in 1997, I believe it was June 7th, they would have equitable principles. So there'd be pre-97s and post-97s, but both of those classes are before 2011.
The statutory class.
The statutory class would be 1997 to 2011, based on those two bases.
Okay.
If you don't prevail on the plain language argument that you've been advancing, explain why the equitable principles survive.
Yes, Chief Justice. I believe that if there's one instance, one case where equity would intervene, it would be in this one. Equitable principles have routinely been used to provide pension benefits to pensioners when they've been made promises, when they've been making reasonable reliances, when the state has given things with the understanding it would continue to do so, and then arbitrarily and unfairly takes them away. One of the unusual things down below before Judge Reisner was that there was absolutely no mention of another published opinion, the Chiarello case. And what Chiarello basically said is that you're entitled to the pension benefits in effect at the time you retire. That is the law that's in effect at the time you retire. That's what governs your pension benefits. So I'm going to speak broadly about equitable principles that they apply to both the pre-97s and the post-97s. And the reason I say before 2011, Justice Albin, is because that's where equity would intervene. Once the law is changed, people are on notice about the change in the law that they would not be receiving COLAs. So I view equity as sort of a rising tide that lifts all boats for those with the contractual right and those without the contractual right. And there are various equitable principles. One is equitable estoppel. I know Ms. Riley had mentioned that there had to be some sort of either misstatement or misleading or fraud on behalf of the state. That's not true. In my written submissions, you only need conduct, speech, some sort of action that causes reasonable reliance for someone to equitably be estopped.
You're not arguing there's been a misstatement.
No. I'm saying they've affirmatively stated they were going to receive COLAs, both the pre-97s and post-97s. In fact, the handbook says once you receive 10 years, you're vested and your retirement benefits are guaranteed. Those retirement benefits in the handbook include cost of living adjustments.
I'm trying to understand your equitable argument.
Yes.
Are you saying that equity comes into play if your argument that the language of the statute is clear is not accepted by the court?
I'm saying both. Even if it,
Why do
even
you,
if it's somewhat
if
unclear.
the statute is clear and unequivocal,
Right.
why do you need equity?
That's why I was asking about the latter.
The
If
pre-97s?
argument- No. If your argument is not accepted,
Right,
make the case on the equitable principle.
right. I think it would apply to both, Justice Albin. The fact that it's a belt and suspenders argument doesn't detract from it.
There's there's a doctrine that equity follows the law.
Right.
So we cannot invoke equitable principles that are contrary to what the legislature has expressed.
I understand.
Agreed?
I don't believe.
Agreed?
I've indicated previously, I think the language, the plain language is clear. But if we look at the pre-97s, for example, those who do not have a non-forfeitable contractual right, these are individuals who served 20, 25, 30 years at work. They gave that many years of their working lives to the state or local government. They vested, they received a pension, they met both the age requirement and the years of service requirement. 2 years thereafter, they began receiving their cost of living adjustments. They have received it, many of them, for 5, 6, 7, even 10 years. They're then told in 2011, without any notice, in a bill that was drafted and passed within 2 weeks, the last 2 weeks of June 2011, and that bill said, we're going to suspend COLAs. The reality, Your Honor, is they're not suspended, they're terminated. There is a provision in the law, and I mentioned it in my written submissions, that when the funding level of the pensions reaches 80%, the specially formed commissions may, but are not required, to reinstitute COLAs.
But when you say there's no notice, there was notice of the statute of the legislative process.
Not to those people who've already retired.
But don't you have a subpoena problem for the pre-1997 employees?
No, I agree, Your Honor. I believe that subpoena would govern them pre-97, but I think equity intervenes and provides them with a remedy. That it is grossly inequitable. It's fundamentally unfair that people who have provided that many years of service.
But even Spooner understood that it's inequitable to upend pension plans. But if the contractual provisions are not clear, so clearly understood that every legislature would understand what is meant by the language, then the contractual provision, there is no contract by a legislature.
You're referring about those who retired before 97, Your Honor?
And I'm looking at our jurisprudence that governs.
I don't believe Spina said that equity doesn't intervene. Spina talked about contractual rights to municipal pension plans. It wasn't about state pension plans. The point I'm making about equity is if there is no non-forfeitable right, if you don't have a contractual right, even Spina acknowledged you had a property interest. And what's surprising about that case, it was written, I believe, in 1964 by this court, there's a quote where they talk about it's too academic to describe the nature of the property interest that a pensioner or retiree has because we can't imagine a legislature making off with a fund. And then we fast forward to now where the Internal Revenue Service successfully sued the state for diversion of pension funds, where the United States Securities and Exchange Commission found fraud by the state in misrepresenting that it was funding pensions. It's a different world.
I don't have Spina in front of me.
Yes.
I think it was written by Chief Justice Weintraub.
Yes.
I think what he was basically saying that in the absence of a clearly written legislative contract, you have to rely on the good faith of the legislature to do the right thing.
He did, Your Honor, but I don't think he said that equity doesn't intervene in an appropriate case.
I don't think he spoke in terms of equity. I don't.
Right, but that's what I'm saying. There's an established doctrine of equitable principles here, equitable estoppel, manifest injustice, fundamental fairness, that have regularly applied for pensioners against the state in obtaining their pensions. Chiarello is a perfect example. It certainly applies any time the state enacts a law that's retroactive and causes an injury. I mean, that's why we have in both the federal and state constitutions rules against retroactivity, whether they're ex post facto, impairment of contract. It's inherently unfair to change the laws, not just in the middle of the game, but to change the score after the game is over. And that's what's happened to those individuals, for example, who retired before 1997. Someone who was a police officer or a fireman for 30 years, who was promised in the handbook a pension and a cost of living adjustment and who's been duly receiving it for many years, maybe even a decade or more, is all of a sudden told, you're not entitled to it, we're going to take it away. And I believe that that's manifestly unjust. It's fundamentally unfair. These people can't rerun the race. They can't go back and get the years of their lives back. They may not be able to get a new job because of their age or health. That's what equity is about. It's to protect us against arbitrary actions of the state. And that's what's happened here. That's why I believe so fervently that equity is just as important as the non-forfeitable contractual right. It holds the states to its lawful obligations.
Mr. Ouslander, I think we have your argument. In the interest of time, is there anything you'd like to add now?
I would, Your Honor. I'd like to just simply close with, I believe that the plain language of the statute, including the exclusion of the health care benefits and the very broadly worded benefits program, is more than sufficient to encompass all the retirement benefits, and that notwithstanding the state's argument that everything has to be listed with particularity, I don't believe the standard has to be one of beyond a reasonable doubt, just that it's clearly indicated as a contractual obligation. This is a civil matter, not a criminal matter, and I don't believe you need that absolute level of certainty.
Thank you.